have a chance.
Yes.
So I'll leave it to proceed, but don't go too much into it.
No, Your Honor, I'm only highlighting some paragraphs. I'm not going through the whole affidavit, because they have already indicated that they want the deponent on the dock for cross-examination. Yes. Your Honor, what we are... Yes, the CCTV, yes. We said paragraph 10, the respondent is the custodian of the station records and the surveillance system, that is the CCTV, that is under investigation. Yes, investigations reveal that under paragraph 11, that the respondent, together with others who are not before court, hired a technician to interfere with the CCTV system at the Central Police Station in a bid to tamper and interfere with the subsequent investigations. Your Honor, we are highlighting what so far we have done insofar as investigations are undergoing. So there is still some investigations which we need, and that is the reason why we are asking for continuing detainment of the respondent, because the respondent's mobile phone has been detained. And it is subject to investigations. Your Honor, there are also witnesses who are yet to be investigated and statements taken from them. Also witnesses, police officers who are on duty at Central Police Station on that night. Your Honor, given that the respondent is the OCS, we are saying that there is a likelihood that he may interfere with the investigations. Your Honor, we'll be seeking the 21 days.
I had forgotten to hit on that issue about be allowed warrants to access their phone. You have mentioned it, but please just hit it. In addition to the 21 days, you're also seeking an order to access the phones.
To continue holding the respondent, and in addition to the 21 days, Your Honor, we'll be seeking an order that we access the phones
Number 18, 17 and 18.
of potential witnesses, the police officers who are on duty, and any other person who was at the vicinity at Central Police Station. And this, Your Honor, we are relying upon paragraph 17 and 18, where we have shown in the paragraphs, we have demonstrated that there is already interference which has already been done. With that, Your Honor, we will be inviting the deponent to the dock for the cross-examination.
Whenever you're comfortable.
Yes.
Cannot be seen. But these are standing to an open step. Will be allowed for 3 minutes for opening step.
No, let him finish. Let him finish, and then you will have your chance. Let him just finish, so that there's that continuous thing. So let's
Yes, please.
Bismillahirrahmanirrahim. Bismillahirrahmanirrahim. I swear by the name of the Almighty God, that the evidence I shall give before this court, touching the matter in question, shall be the truth, the whole truth, and nothing but the truth. So help me God.
You say to the court you are doing.
Your Honor, I am Abdurrahman Jibril. Jibril for you, Jibril. I'm a Senior Assistant Director, Investigations with the Independent Police and Oversight Authority.
Yes. Did you call this affidavit before court?
Yes, Your Honor.
Yes, kindly proceed with the affidavit. There will be questions given from the defense.
Thank you, Your Honor. Your Honor, I am one of the investigating officers in the ongoing investigations that IPO is currently conducting in regards to the brutal murder of Albert Omondi Ojwang. This is pursuant to Section 6, 7, and 25 of the IPO Act. Your Honor, on 8th day of June 2025, IPOA learned the death of Albert Ojwang while in police custody at Central Police Station within Nairobi County. Your Honor, the authority immediately initiated investigations to unravel the circumstances surrounding the gruesome death of the deceased. Your Honor, so far, our preliminary investigations have revealed that the deceased was arrested following a complaint by the Deputy Inspector General of Police.
Your Honor, all that the witness is saying has been said. You can only adopt the report so. Because unless there's any other crucial information.
That's another, Your Honor. That's okay.
Yeah, I was of the view, but just give a highlight, not necessarily going paragraph by paragraph, just a highlight, and then we can adopt it. Just a brief highlight.
Okay.
You okay with whatever you've said so far?
Yes.
And whatever you've averred in the affidavit, yeah? So we can proceed with the cross-examination?
Yes.
Is that okay? The other chap from the state?
That's actually not that.
Okay.
They can proceed to examine on the affidavit.
Thank you. Your Honor, I'll be asking the witness to Jibril.
So, Mr. Danstan, maybe just for housekeeping in good order, how many of you will cross-examine him?
Free.
3. You yourself and who else?
Me, what? Kangai.
So only 3 of you from
Yes,
the
we'll
battery.
cross-examine it.
The three
The
of
others will submit.
I think that is okay.
Thank you. Mr. Jibril,
Yes, Your Honor.
can you confirm your position at IPOA over this matter?
You are asking my rank? My,
Yes. That's a must.
Your Honor, as indicated, I'm a senior assistant director investigations.
And confirm that you are an investigator.
Yes, Your Honor.
Are you an investigator in the purpose and the name or the position of the National Police Act?
IPO Act.
Under IPOA Act. And under IPOA Act, is it true that you have still arresting powers?
Yes.
Under which section?
Your Honor, Section 7 of the IPO Act and Section 7 of the IPO Regulation Act actually gives me the powers, privileges, and immunities of a police officer.
So Section 7. And which section?
Both Section 7 in the IPO Act and Section 7 of the IPO Regulations Act.
Gives you the powers as that of a police officer.
Yes, Your Honor.
And in this matter, you are now actively participating pursuant to those provisions as an investigator.
Yes, Your Honor.
Thank you. Are you well conversant with the law?
Depends on which area you want to ask.
Are you, you know, some of us went to teach, then we became lawyers. Some people are mad about that. Do you have any legal training?
Yes, yes, I do.
Could you refer the court to your legal training?
I'm an advocate of the High Court of Kenya.
Thank you. You are an advocate of the High Court of Kenya. Look at the Criminal Procedure Code, Section 386, as an advocate of the High Court of Kenya. Could you be given it?
Your Honor, we'll have an objection.
I've not asked the question.
We can see. Your Honor,
I've not asked a question.
Your Honor, at least should I be allowed to make the objection?
Yes.
Of course.
Let me just object, then you
No. You wait until I ask. I've just told to look at it. It might be just to admire it. Allow me to ask.
Your Honor, we'll be requesting the court.
Danstan Omar.
Yes.
Let's hear his objection.
Okay.
That's right.
Yes, thank
Your
you.
Honor, the witness before the dock
Yes.
has come here on the basis of his affidavit on the factual matters. And that explains why the defense requested that my colleague, my learned senior, does not go into the facts. Section 386 of the Criminal Procedure Code, or whatever provision of the law, is a matter of law. And Your Honor, the objection again goes into the earlier intended preliminary objection, which we have had sight of, where the argument, in a sense, is that this matter, now we have had a copy, although it's not filed, this matter should have been the subject of an inquest and not a miscellaneous application. So that because we are alert, the defense should not try through the window to bring in a preliminary objection which they admitted not to have filed. But more importantly, that this is a witness of facts, not a witness of the law. We can deal with the law between the lawyers. Thank you.
That's your Honor. Is the law a fact? Yes, it is. Is he a court of law? Yes, he is. Is he an advocate? He knows it. What is it that they are fearing and telling us they are coming through the window? If you come through the window, please respond and throw us out of the house.
There is a submission.
You know,
I've not asked any question. I've only told you to look at that section.
but just for guidance, you know, it's a matter of evidence on the facts. And it's an affidavit, for heaven's sake. So let's leave it to the facts of it.
After I've asked the question,
Yes.
then that is when an inference can be done, whether it's a question of law or a question of fact.
All right.
I've not asked what. I've only told him, look at section 380.
Your Honor, just one more thing. The reason we requested the defense at the very onset to inform us of the paragraphs is that the cross-examination is limited to the contents of the affidavit.
True.
There is no reference to section 386 in the affidavit. They cannot go to it because it is not a matter of fact. If you pointed to us the paragraph looking at section 386, which we referred to, there will be no objection from our end. But because affidavits are leadings of fact, we plead with you to reject the invitation of the witness to look at section 386 or any other provision of the law. Thank you.
I think he was referring to section 386.
Yeah, I just only
So
told him to.
let's not convolute it. Let's limit. It's an affidavit.
Purely, I've not asked any question, Your Honor. If we only had what I've asked, and I ask a question of law, then the court can stop.
Okay, then proceed and ask.
Let him have that. Let him look at what.
But you know,
I've
once
done.
you point it to the law, then it means it's
No.
a point of law.
And that exactly is our objection, that we can't refer to the law. That maybe, see, a counsel is not understanding our objection.
Very well.
Maybe
Very well.
counsel, maybe rather than asking him to look at the law, why don't you put the questions to him?
Correct.
All right.
Just put the question
All right.
rather than us going
Very
to
well.
the.
Very well. Very well. Very well. From your affidavit, confirm the place of death of the late.
Central Police Station cells, Your Honor.
Central Police Station cells. From the AJAABU Act, provide the mandate for you to investigate somebody dead in a police cell.
Yes, Your Honor.
Read, show the court. Because you have confirmed the scene of death is at the police cell. Which mandate gives you that power? Let him answer.
Your Honor, we are still objecting. Counsel is still taking the same route.
He came under the Act. You know, section in this miscellaneous application, paragraph 3, they must have said under which mandate they are coming before this court. And this is a witness.
These are witnesses now.
He's not an advocate. Let him come in front of you. Let him not be given answers.
No, Your Honor. We plead with our colleagues to just remain respectful. We know that they are very good people. Let us maintain the decorum. What we are asking is, as the court has suggested, put the law to the witness. Don't ask the witness to follow the law.
Very well.
We do not mind if you read the law to him and ask questions.
Read paragraph 3 of the Act.
Please read for me so that I can answer.
No, you read it. I didn't write it.
Which one?
Paragraph 3.
That investigations by IPOA are pursuant to section 6A, 7.1 and 25.1 of the IPOA Act.
Is that the law?
Yes.
Is that a fact or that is the law?
That is a fact as per this affidavit.
That's what I'm saying.
Yes.
You have quoted the law. True.
Yes.
Therefore, it is not wrong to ask you a question of law because it is you as in your affidavit talked the law. Give me the law that gives you mandate to investigate a person who dies in a police cell. But it's simple.
I have indicated the sections 6.1, 7.1 and 25.
Just tell the court.
Yeah, Honor, I have indicated section 6A, 7.1 and 25.1 of the IPO Act.
Could you kindly read to the court those sections that gives you that mandate? The IPO Act. Just read to the court those sections for the benefit of the whole one. We don't work for IPO.
Neither do we.
Your Honor, because we did not anticipate that a witness of fact will be made to read the law, we didn't carry a copy of the IPOA Act. If they insist that they want to read it, let them just read it.
Wait suffers from selective amnesia when he is cornered. It is there. On any form. Just read it. Read the section. 6A, you read.
Okay. Section 6, Your Honor talks about functions of the authority.
Yes.
Here means IPOA.
Yes.
That the functions of the authority shall be 6A, investigate any complaints related to disciplinary or criminal offenses committed by any member of the service, whether on its own motion or on receipt of a complaint, and make recommendations to the relevant authorities, including recommendations for prosecution, compensation, internal disciplinary action, or any other appropriate relief, and shall make public the response received to these recommendations. Shall I continue?
Yeah, anywhere where the death of a person in police, specific and so on. My question is specific.
Your Honor, this
Can we allow the witness to read?
This is a question.
Sorry, Your Honor.
Before you even say that, this is a question that has been put to this witness. It is about what he has said in his affidavit. He is being asked to justify why he is here and what gives him the powers. The state, who has not been asked a question, can now stand and start giving him answers or start supporting him, getting answers.
Yes. Yes, Your Honor, I just wanted to indicate. Section 6 has been referred to in the affidavit. The witness has been asked to read, he has read the affidavit. The witness is being asked about the law supporting an action which is not in the affidavit. That's where the difference is. The witness is saying that Section 6 allows us to do A, B, C. But counsel is asking, does the law allow you to do A, X, which is not in the affidavit? We believe that by him having cited to us the paragraphs he would ask questions on, asking the witness about the law allowing you to investigate deaths in cell, which we have not referred to in the affidavit, is going outside the affidavit. But we would be guided.
So it's a bit of contradiction. So let him answer. If it falls under the ambit of that section 6, let him just say
That's right.
it
That's right.
falls under that provision of the law, and let's leave it as that.
That's right. That's right.
And the question we are here about is specific to death inside a police cell. And that is all I'm saying. If he says that section, then the court will go and make a ruling out of it. That's all we're asking. In relation to death in a police cell.
In police custody.
It's not you to set my question. I've asked you my question. You can't set a question and answer yourself.
So Mr. Jibril,
Yes.
If it's not there, it's not there.
the question is, do you have the powers to investigate?
We have powers to investigate death that occurs under police custody.
And that's good enough.
Yes,
That's
and custody includes
The
cells.
report has gotten what we have asked. The question has been answered. We'll do submissions on it. That's all. Let's go to paragraph. Paragraph 7. You are paragraph 7?
Yes.
Read to the court what that paragraph says.
Your Honor, the paragraph says that the respondent was arrested on 13th June 2025 by DCI officers and subsequently handed over to IPOA and was later booked at Langata Police Station via OB 50-13-6 of 25 at 18:05 hours.
The DCI officers arrested him at what time, according to your there?
He said around 3.
You read exactly what you're saying.
I've not indicated the time.
That's I'm asking.
Yes.
It is not indicated when the DCI officers arrested.
Yes.
Where did they arrest?
At the DCI headquarters.
And not Eldoret.
No, Your Honor.
Found that the accused was not arrested at Eldoret.
According to the officers who handed over me to Mr. Taalam, the officers informed me that they arrested him at the DCI headquarters.
Thank you. I'm putting to you that IPOA released a false information to the public that he was arrested in Eldoret en route to escape to Uganda.
That is not in my affidavit.
I'm saying what is in social media is that the respondent...
Your Honor, I can only answer what is in on this affidavit.
Sorry, Your Honor.
Let's not digress to those issues.
Yes.
Yes.
Let's proceed on the question of arrest. Are you aware the Director of Criminal Investigation, my friend Mr. Mohammed Amin, said the respondent is a person of interest?
That is not in my affidavit.
That's why I said, are you aware? If you are not aware, you are not aware.
Counsel, please ask me what is in this affidavit. I'm not going to, Your Honor, I'm not going to answer anything outside the affidavit.
I put it to you that based on the DCI mentioning the respondent, on that day at 2 p.m., he presented himself to the DCI headquarters in the presence of his advocate, Juan Keton. Were you aware of that?
If you said so.
And the DCI authorized these officers together with the advocate to present the respondent to a IPOA headquarters.
Your Honor, we have said time and again.
I'm putting it to you.
Please,
you don't need to answer.
no. Please answer me. Ask me what is in my affidavit. Let's stop charges, Counsel.
Counsel, I've only put it to you. I've not asked any question.
Is it in my affidavit? The question I'm asking to you is it in my affidavit? The answer is no.
Of the court, I'm putting to you. Then I'll ask you where you are saying you are arrested.
Your Honor, I will decline to answer anything which is not in my affidavit.
I've not asked.
Then please ask.
I put it to you that the officers handed over the respondent to IPOA in the presence of Mr. Keto. As I put it to you, for the record purposes.
Samson Taalam was brought to IPOA head office by DCI officers.
And he did record a statement at IPOA in the presence of his advocate, Juan Kiprono. Who is it?
Is that in my affidavit?
I'm putting it to you, counsel. You are a counsel. When it's a question, I'll ask you a question. I'm
Please,
only putting it to you
please ask
for knowledge
me questions.
purposes. So now, if those are the facts, look at the paragraph you said he was arrested. Paragraph 7. Now I'll ask you questions from there. Read.
I have read and read. What is the question, please?
It's a long day.
No, it's a long day, yeah? It's okay. It's okay.
The state is rich, it can bring water.
Yes.
For both of us and council. It's a long day. Can you confirm that paragraph 7 is not true, that he was arrested by the DCI officers?
The respondent was arrested by DCI officers after he presented himself and brought to IPOA.
Do you have any evidence material to that effect? I've given you the scenario the way it was.
No. The fact that he was brought under the escort of DCI officers means he was arrested and brought to IPOA office.
The court has taken that. Let's go further.
So, Your Honor, I think this may be my last objection. We hope that counsel is not proposing to court that he has an alternative set of facts which the court should take note of, because counsel is not a witness. If he wants to give us his alternative facts, we would expect an affidavit so that we also put him on a dock and cross-examine him. Until then, the only factual matrix we have is the one given by the witness before court.
The only way to prove falsehoods is by bringing facts that are truthful. The affidavit is full of falsehoods. We are putting exactly the scenario, and your witness has not recounted any.
So, sorry. Your Honor, I am a believer on the law and procedure. What I understand by the law of affidavits is that a person cannot give us factual matrix, especially a lawyer or an advocate, from the bar. Right now, we have affidavit evidence given by this officer. We are having an alternative set of facts, which may be true. We have no reason to doubt it. But until we have an affidavit, all that he's telling us is, I put it to you. And we hope it does not go to evidence.
Just to allay your fears.
Yes.
The evidence that I'm documenting is from me.
That's right. Thank you very much.
Not from Mr. Danstan.
Thank you. Thank you.
Because as we put it rightly, he's not giving evidence.
Correct.
He knows the procedure.
Thank you.
That's why
He's a teacher of the law.
Yes, thank you. And that's why I told her Witty now is mature to be a judge on the high court. Thank you very much. Let's proceed, Your Honor. Paragraph 9.
Yes, Your Honor.
Paragraph 9.
Yes.
You have said what? About the position of the OCS?
That the respondent at the material time of the incident, he was officer commanding Central Police Station, exercising command of the Central Police Station, hence persons of influence, and has capacity to interfere with the ongoing investigations and likely witness.
Do you have any evidence to show that he was in full command of the police station?
As an OCS, that is...
I've asked a simple question. It is either you have it or you don't have it. Do you have anything, either duty roster or something showing he was on duty or in command?
Your Honor, what the advocate is asking is that you are the presiding magistrate here. Do you have the power of this court? I mean, once you are an OCS, you have got the power over that station. Come on, counsel.
We have agreed that you don't have it. You are looking for it. Let me put it forward. And let me put it to you.
And Your Honor, just to answer also, whatever evidence that I had, I have put as an extra. Anything else which is not here is purposely done to safeguard, first of all, the integrity of the investigations. And they will be provided at the most relevant time. I'm well aware that this will not be the forum where those charges will be preferred. Yes.
So I've asked a simple question.
Yes.
Among the annexures,
there are 9.
You produced an annexure showing he was in command of the police station at the time the offense was committed?
I recorded his statement and he confirmed that at the time of the incident he was the officer commanding station at Central Police Station in the presence of his lawyer. I have not attached in this affidavit.
Simple. The answer is clear. You have
Yes.
not attached. All that's what you are looking
Yes.
for. It's not attached there.
And maybe to answer your question, any other attachment that you might ask is not there, save for the OB extracts,
Just don't go. And you are a lawyer. When I say I put it to you, don't respond. I've not asked any question.
Then why are you putting in the first place? Why in the first place? You can put it there. You can put it all over.
Really went to law school.
So that's if you don't want answers, those questions that you're putting,
I
you're
know.
putting a lot of putting in.
Yes.
Yona, we have our own label here. Allow us to proceed. What is relevant, record. What is not relevant, leave it. I put it to you, the police station, and the deputy was in command as an OCS.
That is not in my affidavit.
And I put it to you that the OCS was never near Central Police Station.
That is not in my affidavit.
Thank you. The world has had something. Let's go, paragraph 15. On the question of him likely to plan. You there?
Yes.
We have agreed there is no any material.
Yes, nothing attached to
Let's
this.
proceed.
Okay.
Paragraph 10.
You go back.
Oh, I asked you paragraph
15. Yes.
I'm going to paragraph 16, sorry.
Okay.
Still no material attacked. It's either very serious material you have kept, no material attacked.
Yes, Your Honor.
Thank you. Paragraph 17 about the CCTV.
No material attached, Your Honor.
Thank you very much. Paragraph 18.
No material attached.
No material attached. Paragraph 17. I've gone back because there's a question I want to ask.
Yeah, please ask.
You have said about the CCTV cameras. Do you have possession of the scene of crime as of now?
No.
Who is in possession of the scene of crime?
The scene of crime was processed and released. Remember, that's a police station. You cannot hold a station as a crime scene for a very long time. So we have released to the relevant authorities.
Is that on oath? Because I was there yesterday. It's not true that the scene of crime has been released to the police.
Then
Is it still a scene of crime, or it is non-operational police station?
that question is not. It's not in my evidence.
You've run very fast. Do not lie that is. So you cannot. There's no material to show that.
Nothing attached, Your Honor.
Paragraph 19.